Okay, good evening, everyone, and welcome to our Thursday night seminar. Tonight it's Property Roundup, and we are joined by our property partner, Michael Shapiro, leading Eileen and Mohammed from the property team in a discussion on current hot topics in the property marketplace. So, Michael, we are ready to be stunned and amazed.
Hello, everybody. As Julie said, I'm Michael Shapiro. I'm the property partner at Silver Shemmings Ash and head of the property team, which has expanded as we've taken on quite a few new people to join us as fee earners over the last few months. I'm delighted to see, at least metaphorically, quite a lot of familiar faces, and also delighted to welcome some new people to our quarterly property seminar. Let me introduce you to everybody first. Eileen Fingleton, who will wave, although easily identifiable, joined us a few months ago as a property litigator. Eileen was previously general counsel in one of the largest property companies in the country and owner, I think, of more ground rents than anybody else. Eileen is dual qualified, as you will see or hear when she speaks, in both England and Ireland. And Eileen specialises in all aspects of property litigation. We also welcome Mohammed Kalam, or Mo, as he's known to all of us. Mo is a paralegal. Shortly, we hope to become a fully fledged solicitor. Mo specialises in development work, acting for buyers, particularly of plots, and he also deals with a lot of residential conveyancing, volume residential conveyancing, as well as specialist leasehold matters, which is what he's going to talk about. So Eileen will start the ball rolling, and she's going to talk about the impact of the Supreme Court decision in the Duval case on both landlords and tenants.
Thank you, Michael. Good evening, everyone. So I think probably most people have heard a little bit about the Duval case. The Supreme Court handed down the decision on the 6th of May 2020, and it has effectively removed the 6th of May 2020. They say allow tenants to undertake alterations, quite commercial impact on landlords. Tenants wanting to improve or add additions to their homes, and also potential buyers, if they're looking to buy a flat, it might be put off purchasing in a block where there are such prohibitive restrictions, and they might be enforced. So the facts of the Duval case are quite straightforward. Randolph Crescent was a tenant-owned landlord company. It managed it owned a block with 9 flats in it. Flat 13 wanted to make structural alterations and requested consent as there was a prohibitive covenant under the lease. The landlord company granted the consent, and then Dr. Duval, who owned 2 flats in the building, objected. So Dr. Duval's objections weren't listened to, I think we can safely say. So Dr. Duval decided to issue a claim against the landlord for a declaration that consent would breach the mutual enforceability clause in the lease. Unfortunately for the landlord, the Supreme Court agreed with Dr. Duval that the grant of the license was in breach of the landlord's obligation to Duval. And there were 3 factors in this. Where the lease contains a covenant, that leases be in similar form, as well as a mutual enforceability clause to enforce tenant covenants on behalf of another tenant, then the landlord will be in breach of consent given to carry out works in breach of the absolute covenant. So I suppose we have to think about what is the difference between an absolute covenant and a qualified covenant. So obviously there are qualified covenants, and that's where a landlord can say that no one can carry out any work without their permission. So that's a qualified covenant. And then there's the absolute covenant, which prohibits any the undertaking of any work, specifically structural work. So the impact of this is quite far-ranging. It won't just affect structural alterations. It could also affect things like, putting in wooden flooring or even pet consents. And although some of these things are dealt with under the regulations in a lease, which a landlord can vary if it's in the interest of good estate management, if any of these are covenants, then many people with bunny rabbits and hamsters will be extremely stuck. So it'll be very sad to say goodbye to, Bunny the rabbit. So anyway, what are the possible solutions? Well, in a smaller block, you could obviously write to all the tenants and ask them if they have any objections to tenant A carrying out structural alterations, and give them a time period in which to respond. And obviously, if they do respond within that time and object, the landlord has to weigh up the risk versus reward element of it. But probably a wise landlord wouldn't do so, because even if it's minimal damages, it's quite a nuisance value type of claim and will cost a lot in legal fees. The other option is obviously for the license to contain an indemnity, whereby the tenant will agree to indemnify the landlord against any legal claims brought by any other tenant who object to the alteration work that the landlord consents to. And then there is another option under Section 84 of the Law of Property Act 1925. A landlord could apply to the Lands Tribunal to allow for a modification of the restrictive covenant, as long as it's impeding reasonable use. And all you need for that is for your lease to be in excess of 40 years, and also for at least 25 years to have expired. And even if the Lands Tribunal weren't minded to modify the covenant, they still might grant authority for the works, particularly if there was only one tenant objecting in, again, maybe a block of 9. And lastly, there is one more option, and it is untried and untested, so it's a theoretical option, and that is if the tenant is exercising its statutory right to extend its lease. And they could argue that an absolute covenant was defective and seek to have it remedied that way. I'm not sure how effective that would be. I'm not an enfranchised lease extension expert, so I think it might be tricky, but certainly I'm sure somebody will give it a try at some point. It will be interesting to see. So just to recap, I think any landlord with absolute covenants in its lease should think hard and fast about actually granting consent where there is an absolute prohibition on structural alterations, and they really have to weigh up the risk versus reward element. And any tenant wanting to make works will obviously also have to weigh up the risks of indemnifying a landlord against any claim, because the legal fees could be quite high. And also, any tenant, any prospective buyer really should look at the lease to see if they want to live in a building where there are such restrictive covenants, particularly if they have a pet. And I think that's all I can say about Duval. So thank you for listening.
Thank you very much, Eileen. Now I'm very happy to welcome Mo. Mo is going to be talking about something that's dear to his heart, because it's what he spends most of his time doing, and that's overcoming pitfalls of owning leasehold property. So Mo, we'll go over to you.
Michael, many thanks. So I'll be using the next 10 minutes or so to briefly talk about what prospective and existing lease owners should be aware of when looking to buy leasehold properties, or if you already own it. So firstly, there are approximately around 4.5 million leasehold homes in England alone, of which 69% are flats and 31% are houses. That number is always increasing, given that we can see all around us brand new residential developments going up, mainly in cities such as London, Birmingham and Manchester. So despite leasehold ownership being a very popular method of home ownership in the UK, there are a number of pitfalls one needs to be aware of during the conveyancing process, or if it becomes apparent during the course of a leaseholder's ownership, then we must look to rectify that issue as soon as it becomes apparent. Failure to act may leave many leaseholders with large legal bills to foot, or even at worst case scenario, it may render their homes either unsellable or unmortgageable, or both. So the first of 3 or 4 points I want to talk about is service charge. So service charge is I'm sure you're all aware, a sum of money paid by the leaseholder to the landlord annually in reflection of the cost that the landlord is expected to incur in that particular service charge year. These things could be such as general repairs, costs of cleaning and maintenance, paying concierge staff, and admin fees. So as I said, service charge is based on estimated figures, which is collected in advance by the landlord, so prior to them incurring the cost. So at the end of the service charge year, if it becomes apparent that they've perhaps underbilled the leaseholders, they're well within the rights in the lease to go back to each individual leaseholders and ask them for the deficit to be paid, of course, proportionately. It's therefore important during the conveyancing process, and this is also more so in luxury developments where the service charge is particularly high, but it's important for a good conveyancer to agree a reasonable service charge retention with the seller's conveyancer. So what that means is, let's say 3 or 4 months into your ownership, you get approached by the landlord or their agent saying that there's a service charge deficit of X amount, you need to pay the X amount by this date. It's obviously unfair for you to foot that bill, given that that particular sum relates to the previous owner's period of ownership. So you simply go back to your conveyancer and relay that correspondence. Your conveyancer will then go back to the seller's conveyancer and call upon that retention. And hopefully, if that's the case, then you'd simply be reimbursed for what you had to incur outside of a period of ownership. The second point I want to mention is ground rent. Now, ground rent's been in the news obviously recently for all the wrong reasons, and in the last few weeks for actually perhaps the right reason, which I will briefly mention. So it's not unusual for the leaseholder to be expected to pay an annual ground rent to the freeholder or the landlord. It's also not unusual for that ground rent to be reviewed periodically and increase. So that increase may either be expressed as a percentage or by reference to an inflation measuring mechanism. The problem lies where there are an increasing number of leases which contain rent review provisions that have doubling ground rent clauses, and in some circumstances, as often as every 10 years. So let's say, for example, we've got a lease that was granted a year ago, which reserves a ground rent of, say, £250 per annum. It has a review provision of to say the ground rent shall be doubled every 10 years. Now, on the face of it, that may not seem a big issue, but if you do the maths and dive further into it, a doubling ground rent of £250 per annum, which doubles every 10 years, you're going to be left with a ground rent of around £64,000 after 80 years. Now, no lender, no high street lender or any prospective buyer would even think of looking at either lending against that lease or even purchasing that lease. So it's important for your conveyancer at the outset to spot such ground rent clauses. And what I often do is, if I do spot ground rent clauses such as this, is I often go back to the seller's conveyancer and ask them to approach the landlord for a deed of variation, asking them to vary that ground rent clause to bring it in line to what's sort of more lender friendly. So that's ground rent for you. The third point I want to mention is briefly, now what do you exactly own under a lease? In other words, it's important to identify what is exactly demised to you under the terms of the lease. Now, just to give you an example of a matter I dealt with not too long ago, I had a client who approached me to obtain the landlord's consent to carry out works to the loft. He was the owner of a top floor flat in a building. So I reviewed the lease, and lo and behold, it became apparent that the loft space wasn't demised to him. So what I suggested is, with that, we approached the landlord asking for a deed of variation for that loft space to be demised. So that's what we did. Unfortunately, the landlord came back and said, yes, we'll give you the demise of that loft space. And bearing in mind the property is in London, it was actually based in Chelsea. The landlord demanded £75,000. Now, my client did actually proceed with getting that deed of variation done and hence demising the loft space to himself, but he also unfortunately triggered stamp duty liability as well. So if those things are not obviously picked up during the early conveyancing process, then you're going to be left with sadly a large bill later down the line when it does become apparent. Fourth point is consent. Now that's landlord's consent for various things that you may want to do during your ownership of the leasehold property. So when owning a leasehold property, it may feel in some instances that you're perhaps a tenant in your own home because your freeholder or landlord generally dictates what you can and cannot do with your property. So for example, if you want to do certain types of work, such as a loft conversion or a basement conversion, or perhaps knocking down an internal wall to create more space, I can almost guarantee you that you're going to need the landlord's consent. So even before commencing the works, you're going to need the landlord's consent and the license to alterations. So even before commencing the works, you're probably going to be left with footing a bill or thousands of pounds by way of legal fees for yourself and the landlord, and in addition, surveyor's fees and architect's fees as well, and not to mention planning and building regulations if necessary. Other consents relate to things such as when you come to selling or assigning the lease. Again, this is more common in luxury apartments. For example, say in London, the landlord wants to specifically give you consent to assign generally for 2 or 3 reasons. So one being, it gives them the opportunity to vet the incoming leaseholder, especially where the ground rent is high, because they want to ensure that the incoming leaseholder will not default in paying the service charges. And secondly, obviously, if there are existing breaches of covenants that relate to your period of ownership that they want remedied first, they'd want that done first before giving consent. Also, you may need to seek the landlord's consent if you're looking to sublet your apartment, although in such instances, the landlord cannot unreasonably withhold consent. And again, going back to service charges, perhaps that's one of the reasons why they may wish to withhold consent if there are unpaid service charges. So yeah, that brings an end to the pitfalls of owning leasehold property.
Mo, thank you very much indeed. And I'm sure that there will be questions for both of you because both of your talks are very relevant and practical. So I am, as many of you know, I'm a commercial conveyancer rather than a residential conveyancer. And I'm going to talk to you for the next few minutes about something that I do regularly and indeed is about half at least of my day-to-day work, and that's acting for a tenant, be they an investor or an occupier, where there is a foreign element, particularly in the taking of a lease rather than in purchasing, but I will touch on purchasing. Now, the key is, and the number of people who say to me, where I may have acted for a foreign company buying or acquiring a leasehold interest in England and Wales, could I also do their conveyancing? Somebody asked me a few months ago. They were buying a retail shop in Milan. And believe you me, I would have loved to have spent a week or two in Milan, but we as English solicitors can only act in relation to the acquisition of properties in England and Wales. The first key thing that I always say to clients when I hear the word foreign is, if you're looking for a property, you must get an agent who understands some of the, not necessarily the pitfalls, but some of the additional problems that can occur, particularly in the early stages of a transaction, if the landlord sniffs that there is a foreign element, mainly because it's much harder to chase a tenant who is essentially based abroad and they don't pay their rent. So that is a key point, and there are a number of specialist agents that we have all dealt with in the office. The first thing that will need to be done is the anti-money laundering, and this is generally particularly if there is a foreign company is the parent of the English company, which has just been set up to take over some premises. Enhanced anti-money laundering is nearly always required because invariably, particularly if it's a new co set up to take premises, they'll be asked to give a guarantee or provide a rent deposit or a rent bond. The parent company will do that, but the parent company may be based, for example, in Germany. And the English system is such that anti-money laundering has to be dealt with. So it's the usual identity of the person giving you instructions, and most importantly, where the NewCo English company sits within the structure of the parent company. By coincidence, I have got 2 or 3 transactions that are almost identical at the moment, but it's like getting over a hurdle to persuade the landlords to accept either a parent company guarantee or a rent deposit. Indeed, on one matter, the rent deposit has to be placed not in the client's bank in Frankfurt, but it's got to be placed in a bank account in England. So let us assume that all the anti-money laundering has been dealt with, the heads of terms have now been agreed, and we are dealing with the English company. One needs to be realistic on the timing because a transaction where there is a foreign element invariably takes longer. The next thing is to look at the structure of the transaction. If it turns out that the client may be an investor or may be buying the freehold of a building rather than a leasehold interest, it can either be an asset purchase by the new co or a share purchase of the shares in the company that holds the asset. Otherwise, it'll just be a straightforward letting, grant of a new lease, or an assignment of an existing lease. Key point at this stage then is to bring in accountants who understand, again, clients taking a property with a foreign element, because obviously we are not tax experts, indeed we're not tax advisors, so most important to have an accountant on board who can assist. Because private international tax law, there are complications, there are tax treaties. I'm not sure what Brexit has done to it. I don't pretend to understand. I just farm it all out to the accountants. The next thing that one will have to look out for is when the landlord says, I need an opinion letter. So I have had people say, what is an opinion letter? An opinion letter is something very straightforward. I've actually provided them for foreign companies where we're the other way around. In other words, the parent company is based in the UK, and I had one last year where a client's subsidiary in the States was taking a property in Boston. And again, they didn't need me to go over, but never mind. Again, private international law does come into this, but an opinion letter is basically exactly what it says. It is an opinion by a lawyer in the jurisdiction where the company is based, confirming that the company has been properly constituted, i.e. the equivalent of memorandum and articles of association, that the people who will be executing the documents are properly empowered to do so. And please try and avoid a power of attorney, because foreign powers of attorney can cause mayhem. And finally, that the company is able to enter the transaction and that the directors understand the nature and effect of it. If we are dealing with an agreement for lease, most good landlord solicitors will want to see that opinion letter before an exchange of an agreement for lease, and then an opinion letter on the day of completion. So lining up the local law is very important. I tend to say to clients where their parent company is abroad, can you put me in contact with your regular lawyers? Much easier, because then it's just me and him or her, and they know the company well enough that they can prepare the opinion letter. So we've then got the basis of the transaction. It proceeds in the normal way: searches, title, some drafting, looking at the lease or assignment of the lease, rent deposit deed, possible license for alterations, and also checking the planning carefully. Planning is one thing that has changed, as we all know, in the last couple of months, following the new regulations that came in last September. And one reason why the market over here has improved is because we are now permitted to demolish and rebuild unused buildings, repurpose properties, for example, retail to residential, possibly without having to obtain planning consent, potential rezoning, redevelopment opportunities. A lot happened really because of COVID and the general sort of decline in the retail high street, which has become attractive to people who are investing from abroad. So hopefully all the ducks are in a row, we complete, and then the client invites me to the opening of their new showroom. So thank you all very much for listening, and I'll be happy to take any questions. Thank you.
Okay, thank you, all three of you. That was an interesting roundup. We've obviously learned that Michael likes to travel internationally at every given opportunity. We've had a couple of questions come in. The first one is, do the panel think that the ground rent charges for leasehold apartments will eventually be scrapped? Who'd like to field that one?
Mo, I think that's probably for Mo, and Eileen might have a comment as well, having come from the largest ground rent owner in the country. So Eileen, why don't you go first and then hand over to Mo? Well,
actually, it's more that I come from Ireland, and in Ireland we have long leasehold on flats, but there is no ground rent. So there's only service charges. So Ireland doesn't have any ground rent if it's long leasehold flats. So there are 999-year leases on flats with no ground rent. And I think over here, I think any ground rent that's probably more than peppercorn probably will eventually, and say very, very, very far in the future, probably be abolished, because it doesn't feel like it can continue as is. But it will obviously make any leaseholds that have an existing ground rent more valuable, I think, to any purchaser. So that's my opinion. Not legal at all.
I agree. Yeah, I agree with Eileen. I forgot to mention when I was talking that the Housing Secretary announced a few weeks ago that proposals are in the pipeline to allow leaseholders to extend the leases to 990 years and reduce the ground rent to a peppercorn. The existing laws under relevant regulations do allow you to extend your lease by an addition of 90 years and again reduce the ground rent to a peppercorn. But the difference with the proposed reforms is that they will look to get rid of the marriage value, which would substantially save costs for the leaseholders.
Okay, on that same topic, another question here. What happens to a lease when the number of years remaining on it gradually reduces? Do you just get granted a new lease, or does it cost you anything, the leasehold, or anything?
Good question. Obviously, if you've got a very generous landlord, they might look to give you a lease free of charge, but I've never seen that, so I doubt that's the case. So as the term of years in your lease decreases, the value of the lease also decreases, so that's known as a wasting asset. Usually if a lease drops below, say, 80 years, again, lenders will refuse to touch it. That's because, not many people can buy it with an aid of a mortgage. You normally get a statutory right to extend your lease under current legislation if you've owned it for at least 2 years. The process is a quite lengthy one, but just to briefly sum up, it's initiated by serving a statutory notice. So the tenant will serve a statutory notice. The landlord will then have a period of time to respond. More often than not, the landlord will come back and say, we agree that you do have a right to extend your lease, but we don't agree with your premium. That's where your surveyors get involved. And once the premiums are agreed, you then get granted a new lease of 90 years with the rent being reduced to a peppercorn. So that's generally how a lease extension works. Okay,
thanks for that, Mo. Someone else, Eileen, is going back to the point you were talking about earlier. They're saying, I own a block of flats and one of the leaseholders wishes to carry out some structural works to their flat. They've been advised that there is an absolute covenant against structural alterations in the lease, and the leases are all in a similar form. In the light of the Duval case that you were mentioning earlier, how should they deal with that request?
Well, I think it goes back to the question of risk versus reward. So I guess the first question is, given the circumstances are similar to Duval, how much is the premium being offered for this waiving of the covenant, not to be completely mercenary? So I guess there's that question first. But then obviously, as I said in my talk earlier, there are 4 options that I'm currently aware of. So obviously the first is to canvass the other tenants to see if they have any objections to allowing for this alteration under the lease. And if there are no objections, then to proceed, but obviously to obtain an indemnity from the tenant against any potential legal claims from other disgruntled tenants. And as I said, and then there's always Section 84 of the 1925 Act, and also I suppose the option for the tenant if it required a lease extension. But from what well, from the very little information I know, it doesn't sound like the lease extension option might be a goer on this one. So I think it's probably the first 3 really.
Okay, so as usual, seek advice. Michael, here's one that I think is definitely for you because it involves Italy, so international travel. Someone here's writing that they're the UK sales director of an Italian furniture manufacturer who wants to set up another showroom in London. No travel, sorry. They're also the MD of the English subsidiary company, wholly owned by the Italians. And they were really interested in what you were saying because they feel they're about to enter a very dark, bureaucratic and legal nightmare. They've dealt with lots of leaseholds in a previous job, but how do they start to explain the concept of leasehold, let alone covenants and encumbrances to the parent company?
Oh, that's the sort of thing that I often get. Now, firstly, audience, just that you know, I've been doing property transactions with a foreign element for getting on for 20 years, and I have never once been anywhere other than my own desk. As it happens, last year, I very nearly had a day out in Frankfurt, but due to COVID, we did all the meetings on Zoom. So I just want to make that absolutely clear to you all. Now, this is the $64,000 question because most newcos will have an English MD running it who is really enthusiastic to get his showroom, offices, warehouse open, and then he stumbles across the Europeans, the Scandinavians, or the Americans, because our legal system is not like anything else. Our property legal system is not like anything else really in the world. If you have ever tried explaining what an FRI lease is or what a rent review clause is, even to foreign lawyers, it is, I can understand why your questioner is saying he feels he's about to enter this very dark legal and bureaucratic nightmare. So what I do is I always report to the guy on the ground, the Englishman, and I go through, as always, all the searches and all the documents. We then come usually to the opinion letter, the possible rent deposit deed or the parent company guarantee. And what I always do is pick up the Zoom. One of the few advantages of COVID has been that I don't have to go through these hour-long conference calls where you can't actually see who you're talking to, because now everybody's got some sort of video conferencing platform. We have to be practical and commercial here, and I always follow that well-known acronym KISS, keep it simple, stupid, because that way you explain to the parent company, the director, who hopefully and generally and rather embarrassingly probably speaks as good English as I do, exactly what is involved. But I keep it as straightforward as possible. I always say I've explained to the English MD about any covenants, encumbrances, etc. But generally, I try to keep it as simple as possible. But the key is to make sure that whoever you're speaking to, wherever it is in the world, understands the nature and effect of giving a guarantee or having a rent deposit. So hopefully that has answered your question. And don't worry, the bureaucratic and legal nightmare is what you're paying me to go to. You just hopefully start planning your showroom. Thanks.
Right, so lots of paracetamol, but no international travel, Michael. Okay, we've got it. Okay, another question coming in here. Why aren't all commercial leases inside the 1954 Landlord and Tenant Act, which is the case in the USA, where the tenant has more control?
Yes, that's something else. Try explaining to people, particularly the Americans. Okay, so for those who might need a little refresher, the Landlord and Tenant Act 1954 Part 2 has provisions that a lease can be taken outside the security of tenure provisions. This used to be dealt with when I first started practicing by way of a court order, and it used to take although it was a standard rubber stamping job by, as they were then called, county court judges, it would take a minimum of 8 working days, and they didn't let you take the order in personally unless you had evidence it could be expedited. Now, to speed the process up, it's dealt with by way of a statutory declaration. A formal notice under the Landlord and Tenant Act is served, basically setting out that at the end of the term, the tenant will have no right to remain, which means that on the last day of the term, the tenant has to go unless they can renegotiate it. It's dealt with by somebody who is authorized to swear the statutory declaration doing just that, which confirms that they understand the nature and effect. And there is a clause in the lease confirming that notice has been served. Often the notices are next to the lease, and then once completion has taken place, that lease is outside the Act, and outside the Act is shorthand for saying outside the security of tenure provisions. One thing that happens in this country is that particularly shorter leases are not within the Act, so they are outside the Act. A lease that's longer than 10 years, I would generally expect to have some security of tenure, because after 10 years, somebody will have spent a fair amount of money improving the premises, doing works, all with consent, of course. And it is usual, but not mandatory, for longer leases of commercial premises to be inside the Act. So hopefully that has answered your question.
That's great. Thank you very much. Okay, that seems to be all the questions for this evening. So thank you everyone for attending. Our thanks to Michael, Eileen and Mo for their expertise and time. It's always appreciated. Next property roundup will be in 2 months' time. Next month we have the construction team who will be expounding on latest topics in the construction market. Next week, our next seminar on Wednesday morning is construction case law updates, and that will be with Mohammed Kalam. So if anyone would like to place on that, please don't hesitate to email me on seminars@Silver LLP. As always, the guys can be contacted. It's Michael Shapiro at silverllp.com, Mohammed Kalam at silverllp.com, and Eileen Fingleton at silverllp.com if there's something you'd like to ask them that you didn't particularly wish to raise in an open forum. So thank you, everyone, and good night. And thank you, panel. And we look forward to seeing you
everybody
again soon.
and thank you everybody for joining us. Take care, everyone. Bye.
Bye-bye.